Hello, I'm Dr. Maggie Hall, and today I'm going to talk about social media and human rights in 15 minutes or less. This module is coming to you from the Goldstein Family Community Chair in Human Rights at the University of Nebraska at Omaha, with special thanks to the Goldstein Center for Human Rights. We're going to concentrate on the nexus between due process, privacy, and the age of social media. A lot of what we understand about due process and privacy as human rights is guided by our understandings of national and international law. It's important to contextualize the nexus between these areas, both because there's currently little guiding legislation about when and how social media companies should create structures to protect private individuals, but also because the use of social media applies a lot of pressure on how we as individuals understand and interact with these laws. As we'll talk about today, it has proven difficult to maintain human rights online. So let's start with definitions. Human rights are rights because they have the force of law behind them, like the U.S. Constitution. Due process is generally understood to be your right to be treated fairly. Due process, in an American understanding, strictly refers to the relationship between the governing agencies, like the state and the federal government, and the individual. The Constitution does not include private industry or commerce. Due process is codified under U.S. law in two ways, as the 14th Amendment's Due Process Clause and the 5th Amendment on Criminal Procedure. Due process is a main vehicle of the Bill of Rights, which are considered to be fundamental rights for Americans. Privacy is a broad term. It defines things that are part of us, such as our body, our home, our property, our thoughts, feelings, secrets, our identity. The Constitution does not explicitly include the words right to privacy. However, individual as well as locational privacy are implicitly guaranteed by the Constitution under the 4th Amendment, which you can see written here on this slide. Privacy is also generally considered to be a customary international human right. Colloquial understandings of due process and privacy sometimes combine the two rights into one. This is understandable. The text of the International Covenant on Civil and Political Rights, which is an international legal document that deals with human rights, refers to privacy in terms of attacks on personal honor, reputation, and the protection of the law against unwanted interference. The next most important thing to discuss is that there are two conceptions of rights, positive and negative rights. Positive rights carry the duty of government and any of the affiliated agencies to facilitate their exercise. You can think of positive rights like the rights of an individual to join unions. Unionization is a right connected with the First Amendment, the freedom to associate. Unionization is broadly held as a human right internationally, but there are structural aspects that are required by the authorities in place to facilitate the formation and joining of a workers' union. The agency in charge needs to support a unionization drive, a vote of unionization, and union activities like collective bargaining to realize this right. Those obligations to take positive actions are what makes a positive right. Negative rights are the duty not to interfere with the exercise of a person's rights. Negative rights are inane to the person. No additional government facilitations are required for the right to exist. Now, one of the most discussed negative rights is, of course, the right to free speech. What we generally mean by the right to express one's ideas and opinions is freely expressing through speech, writing, and other forms of communication, but without deliberately causing harm to others' characters or their reputations by false or misleading statements. This begs the question, if free speech is a negative right, which means there should be no barriers to expression, does that mean that free speech is absolute? For sure, there are exceptions to free speech, like child porn, slander, or libel. In the case of private companies, as opposed to government agencies, like social media platforms, there isn't actually a right to speech because it's regulated by government. But because freedom of speech and expression are negative rights, there are high barriers to enforcing speech-related protection for anyone who is impacted. People who are marginalized or who are vulnerable are often required themselves to prove that their positive civil rights have been impacted by the enactment of somebody else's negative rights. For example, those subjected to child abuse that has been digitized and shared are personally required to pursue court cases against each individual that obtains a copy in order for there to be legal punishment. There are also often power differentials at play. Like this, we are able to draw a direct line between the racialized claims of Carolyn Bryant Donham, who was the accuser of Emmett Till, and the claims of Amy Cooper, who falsely called the police on a bird watcher in Central Park, claiming she was being threatened by an African-American man. This is important because while the internet didn't invent the angry mob, it certainly sped it up. This brings us to social media and its role in facilitating our human rights. There are currently no explicit or new laws that compel social media platforms to comply with human rights. As we said before, rights like due process and privacy are between a person and their government. This does not generally transfer to private commerce like social media platforms. That is part of the reason why it can be so difficult to guarantee that respect for human rights is exercised online. Due process holds that no person shall be deprived of life, liberty, or property without due process of law. The 3 pillars of due process standards include receiving notice of allegations, having an opportunity to respond to those allegations, and having a neutral party hear the allegations and declare a ruling. We know that these standards, as they stand, are practically unenforceable in a digital social environment, where all forms of content move at an absolute breakneck speed. We know and have seen repeatedly that the free expression of some views encroaches on the dignity and the freedom of other rights. There are 2 sides to this encroachment in the social media realm: the personal and the business model aspects. Social platforms' business model monetizes your time and attention on their platforms, so we're incentivized to have a permissive or an unregulated view of speech. A U.S. law, Section 230 of the Communications Decency Act, rules that content providers are not responsible for materials posted by users, which gives the providers even more incentive to leave platforms unregulated. As a business model, unregulated speech can encroach on other rights and can create a de facto prioritization of ranking of our rights. In this case, meaning that the rights to free speech guaranteed in the First Amendment are more powerful than other fundamental rights, like those guaranteed in the 4th, 5th, and 14th Amendments. Most social platforms, including Facebook, Twitter, Reddit, are strongly pro-free speech platforms. In July 2020, Facebook faced a critical public audit on exactly this basis. The audit faulted Facebook for its lack of civil rights infrastructure, for the prioritization of speech over other rights, and for the unequal treatment of the famous and powerful compared to the lay users of the platform. By applying no barriers to speech, as expected of a negative right, the audit found that Facebook inadvertently deprived its 2.7 billion customers of their positive right to be treated fairly. Facebook was missing the additional requirements in place for positive rights to take place and be protected. As such, the auditors found that Facebook's business model could be liable for lack of protection of human rights due to its failure to uphold fundamental rights as a legal entity inside of the United States. Like this, the auditors are positioning Facebook as a tool to deprive individuals of their rights. That functionality isn't explicitly covered in Section 230's wording and may serve as a model for holding social media companies liable when they do not adequately protect individuals' rights. Potential encroachments regarding due process and personal aspects are based on what makes social media so easy to use. There are nearly unlimited ways to find and share information both broadly and instantaneously. But what makes it so fun to share on Catterday can be devastating when people are facing a jury of their peers online. One of the first widely known public shamings was of a 2012 prank picture of a woman named Lindsay Stone. When on an outing at her job working with adults with developmental disabilities, she was photographed in a picture that is widely seen as offensive. 4 weeks after the picture was posted, it was publicly available and found on Facebook. A massive backlash occurred against Ms. Stone, including the creation of a Facebook group called Fire Lindsay Stone, which at its height had 18,000 members. It is still accessible today, 8 years later. On the one hand, Facebook served its business purpose of allowing Ms. Stone's free speech. On the other, groups demanding retribution were able to have her fired from her job without respect for due process that should normally be afforded to a person. When there is neither a right to speech on social media nor a requirement for due process from a private company, we can clearly see that the 3 pillars of due process were not met in this case. If due process is the right to be treated fairly, privacy is the right to decide what is in the public domain and what remains confidential. Let's spend a little bit more time looking at the incident surrounding the viral episode between a bird watcher and a dog walker from the perspective of human rights. It's very clear that the bird watcher, Christiane Cooper, had his rights violated. Amy Cooper committed slander when she falsely reported Mr. Cooper as threatening her on a 911 call. The difference between this incident and similar incidences is that by recording and posting the interaction from his cell phone, Mr. Cooper was able to document the slander in real time. Recording and posting then enabled Mr. Cooper to meet the burden of proof that usually has high barriers, namely when 2 parties or each party claims to have a different version of events. He was in effect able to prove his right to due process by recording it. In the 24 hours immediately after being posted, the video had 30 million views on Twitter and 21,000 shares on Facebook. The virality of the video raises thorny questions, like what rights did Ms. Cooper have after the video was made public, considering the right to privacy? Now, some would say that by violating his civil rights, Mrs. Cooper negated her own. Unfortunately, that's not how rights work. Others, including public statements by her lawyer, are just outraged by what's being called colloquial cancel culture, arguing that by publicly shaming her, their reaction itself is criminal. That's also an incorrect understanding of human rights as it pertains to rights like privacy, because social platforms are not regulated as governmental agencies. It begs the question, can a person claim unreasonable search and seizure, attacks on honor and reputation, or even arbitrary interference when something concerning them goes viral on social media? A simple search of the name Amy Cooper on your favorite search engine will return hundreds of thousands of results, some containing very sensitive personal details. First, we know her name. This was not a part of the original video. We know the names of her former employees and the building that she lives in. We know her immigration status and the year she immigrated from Canada. We also know that linked to the video, Ms. Cooper was forced to surrender the unleashed dog by its adoption agency. We know the name of her former employer, her rank at that firm. We know the names of individual investors who called the investment firm about her employment there, and we know the date of her firing from the agency. We also know her employment history from past decades. We have hundreds of still images, both surfed from other social platforms of hers, as well as cut from the video, that very clearly link a face to a name. We know that she faces 2 current investigations, one from the New York City Commission on Human Rights and one from the district attorney. We also know that she was involved in a previous legal dispute against a married lover. So, what all do we have access to? In a very real sense, we have a semi-complete portrait of a woman's life. In a legal sense, this is not a human rights violation because it does not emanate from the government. Amy Cooper has not had her right to privacy infringed on by the federal or state government. But in an essential sense, Amy Cooper has lost her right to decide of what of hers should be public and what should be private. Social media plays a Janus-faced role in this case, or others like it. While the use of social media supported Mr. Cooper in maintaining his human rights, the unregulated use of social media also continues to support the loss of Ms. Cooper's. Summing it up, we know that the rights to expression, privacy, and due process are fundamental human rights. We also know that private commerce is generally not liable for the content on their sites, including items which can deprive people of their fundamental rights. Recent changes in the way we use social media is causing platforms to reconsider their unregulated stance, which means that the future is unclear if and how human rights are going to be recognized on social platforms. These considerations, as well as our own behaviors, are creating novel legal and rights-based issues that are not in place when the U.S. Constitution or any of the international laws governing human rights were written. There's pressure across the board to manage social media in a way that's rights conformant, and for the creation of new laws and statutes that reflect modern society. A particular pressure exists between negative and positive rights on social platforms, and how we can build platforms whose use would be consistent with all rights and not just a few. You've undoubtedly noticed that this challenge is fiercely debated. Even if it seems polarizing or difficult, this debate and the open challenge it represents is necessary in order to better shape norms for how we use social media in the future.